Hi, I'm Amy Walters. I'm an attorney at the Legal Aid Justice Center. And Rob Hagenclass is with me tonight. He's going to be my slide clicker because I seem not capable of doing two things at once. If you're wondering about my screen behind me, I am in my closet because I am a parent and trying to ignore the sounds that I'm hearing from outside and keep little people from interrupting tonight. And unfortunately, I couldn't get a tropical background in here for y'all. But anyway, this is week 4 of our 5-part series, and we're focusing on kids in the juvenile legal system. And I really just want to thank y'all for being here tonight this week. Seems like a doozy, at least for me, with school starting and everything going on with the pandemic and everything going on with the news. And I'm just so impressed that y'all showed up tonight. And if you're watching a recording of this, I'm so impressed that you made time in your schedules to do this. So thank you so much. Hopefully, I can honor that by being prepared tonight. Thanks, Rob. Okay, so here's what I want to do today. I want to talk about the ways kids enter the justice system and then kind of provide an overview of the process once they're there and what kind of outcomes can happen. And throughout, I want to highlight critical moments where parents or advocates can kind of step in, especially as it pertains to kids with disabilities, how that might impact the process. Thanks. Okay, so if you were here, next slide, please. If you were here week 1, I showed this slide, which is sort of an overview of law enforcement process for kids. And I'm going to be using this slide a couple times to kind of show what we're talking about. So we can see the flow chart here going from the incident, the police contact, and you'll see that again. Thanks, Rob. You can go next. So before, though, we get to talking about the juvenile legal system, which people tend to think as juvenile court. We have this sort of preliminary question of when we're talking about kids who have committed crimes, are we treating them as kids in the juvenile system, or is under Virginia law, are they going into the adult system and in many ways as a law looking at them as adults and treating them as adults, and they're going to circuit court? So the law in Virginia controls generally where a kiddo ends up and at this stage, and it's kind of nuanced. But oops, previous slide. Thanks. Yeah. So to start off though, so just wanting to show distinctions between the two, right? The juvenile justice system in Virginia takes place in the JDR courts, the juvenile and domestic relation courts, whereas kids will who are charged as adults end up in circuit court. The same place that hears civil matters where people sue people, the same place where adults who are charged of felonies end up, they're in their local circuit court. The philosophies of these two courts and the judges that practice within them are quite different. So the philosophy of the juvenile court and the juvenile code, meaning the laws that govern juvenile crime and what the powers of the court and all that, are guided by the best interest of the child standard. And so when it comes to juvenile justice, that thought process of the kid involved in the system, the best interest of that child is considered along with the impact on the victim and the safety of the community. So when a court's deciding what to do with a child who's committed a delinquent act, they are thinking both about what's best for that child and what's best for the community. Of course, in the adult system, the primary concern is public safety. Their rehabilitative goals, and to the extent possible, kind of like in special ed law, how we have this least restrictive environment hook with our IEPs, where kids are supposed to be educated in the least restrictive setting possible. Same too with kids involved in the court system, if they're in the juvenile system. The idea being that we want to be in the least restrictive setting for them where they can get rehabilitative treatment while also protecting the community. And one thing most people know just from their experience in life or watching TV is that, the juvenile courts are courts not of record, not public. The records kept there confidential. And if a kid is adjudicated delinquent in juvenile court, this is not a conviction for purposes of filling out a job application, later down the road or something like that. As opposed to if a kid is in adult court and gets in a conviction, that magic word, then that felony conviction stays on their record forever. And so the language we use in these two systems is a little bit different, right? But you can see this chart on the right, which, in the juvenile system, we say it's offense, maybe it's a crime in the criminal system. Take a kid into custody sounds a little bit more neutral than arrest. We petition the court. That's okay. For when, rather than file charges, we don't have a trial, we have an adjudicatory hearing. Rather than being convicted of a crime, the child is either found to be delinquent or found involved. Rather than sentencing in juvenile court, we have a disposition, right? What are we going to do with the case, as opposed to sentencing more narrowly, thinking about a quantifiable period of time or quantifiable fine only. Detention versus jail, and commitment to the Department of Juvenile Justice versus incarceration. So I'm so enmeshed in this stuff that I might use these terms without even thinking about it. But this will tell you a little bit this kind of tells you the language used a little bit about the philosophies of the two court systems and how they might deal with a kid. Okay, thanks. So kids in circuit court, right? So most kids, and what I'm going to focus on in this presentation is going to be kids in juvenile court, because hopefully that's most. But how do kids who end up being charged and go through the process in circuit court, how do they get there, right? Well, the answer to that largely depends on their age and the crime that they're charged with. It may also be impacted by their previous court involvement. But some crimes for certain ages are automatically certified to adult court. So a 16-year-old or 17-year-old who is charged with murder is going to automatically be treated as an adult under the law, and their case is going to be heard in circuit court. Another group of kids, based on their age and the offense they're charged with, might end up in circuit court because the prosecutor in the case has a discretion to file the charges there. So it's not a judge saying it, it's actually the Commonwealth's attorney who controls that decision. And once it's filed there, that's where the case is, for the most part. A third group of kids have a hearing to determine whether they should be tried in juvenile court or circuit court. These would be kids who are on the younger age or crimes that are sort of less serious, still felonies, but less serious than, say, murder. At that hearing, a bunch of factors are considered by the court to determine whether that kid should be sent to the adult system or kept in the juvenile system. And one really relevant aspect of that might be their trauma history, their disability, the things that sort of make the child unique circumstances, uniquely suited to be treated in the juvenile system as opposed to the adult system. And so I don't want to spend too much time on that here, but if someone's in a situation where your child or you're working with a kid who is facing one of these transfer hearings, definitely provide information about that child to the child's attorney, to the court, so that they have the opportunity to consider all relevant information before having that child go into the adult system. Once a kid is in the adult system, right, usually they are classified as a serious juvenile offender, or serious juvenile offender. And these kids are sort of a thing unto themselves. They are kids in the adult system. They, like I said, if they're convicted, they get that conviction on their record for the rest of their life. But in Virginia, it doesn't necessarily mean that just because you're sentenced or convicted as an adult, as a kid, that you will spend time in the Department of Corrections, in the adult prison system, right? Even though you're being treated as an adult, the judge still could sentence you in the same way as if you were a kid. So you have this adult felony conviction on your record. However, your sentence is only to be in the Department of Juvenile Justice for, say, until age 21. That's a really common sentence. That kid will never have to step into the doors of a Department of Corrections prison facility, unless they get future charges, and they stay in the juvenile system, but those adult consequences persist. The judge also in Virginia could sentence a youth to a blended sentence, sometime in the juvenile system and sometime in the adult system. Or the judge could give them strictly adult sentence. So even though they're a kid, they could end up in the adult system altogether. So a unique entitlement right, oh, we're going back. Unique entitlement right for serious offenders is that after 2 years in the juvenile system, if it's a kid who has a blended sentence, meaning time in DJJ and then time in DOC, or that third category where their adult sentence is suspended on condition that they complete a juvenile sentence, meaning that as long as they successfully complete the juvenile sentence, they don't have to go to adult prison. In either of those circumstances, after 2 years, the judge holds a hearing to look at the kid again, to revisit the kid's sentence. It's called a sentence review here, or a serious offender review hearing. At these hearings, the court looks at how the kid has progressed while in DJJ, and it's an opportunity for the court to reconsider the initial sentence they gave the child in light of their rehabilitation. This is kind of a special tool of Virginia law where we realize, we in the 90s kind of like not put everyone, but we were really strict on crime, started thinking about kids as miniature adults and then thinking if you're old enough to do the crime, you're old enough to do the time. And then we kind of swung back a little bit and like, well, wait a minute, kids are different. What do we know about them? Their cognitive development, what is the brain science telling us about them? What do we know about their chances of recidivism? How are they different actually from adults? So let's our initial impression of this kid at sentencing might be, oh my goodness, this 16-year-old committed an armed robbery. But after 2 years of being behind bars, getting therapy, getting anger management, getting educational services, and all those things that DJJ is putting in place, it might be that that child has developed and matured and been rehabilitated and looks completely different than the kid before the judge 2 years before. And so it's a unique opportunity where, again, there are statutory factors. The law specifically tells a judge things to consider when deciding whether to modify the sentence, and a child's educational progress or disability can be really relevant to that decision. Okay, so I'm going to go, next slide, please, Rob. I'm going to veer away from adult court, kind of like the deepest end kids, and focus a little bit now more on the juvenile system. So there are juvenile delinquency charges, right? That's kind of what comes to mind when somebody thinks about a kid in court having committed a crime. But there are also other ways to get before the court in Virginia involving status offenses. Status offenses mean things that are only a crime because of your age, right? So like having alcohol underage is a status offense. And what I'm going to focus on here is CHINS and CHINSUP, which you might have heard. CHINSUP, which stands for like Child in Need of Supervision, is a mechanism of law where a child has been truant, and there are statutory factors in place that the court must see that happened at the school end of things. When a kid's been truant from school, meaning they've missed school a certain number of days, there's supposed to be a meeting with a truancy officer. These things are supposed to happen before it comes to court. But if those things have happened and the kid is still missing school, then the court may get involved with a CHINSUP petition, meaning this kid's truant, we need court involvement, right? I will note that there are also criminal consequences that a parent can face if their child is truant. But anyway, so back to truancy, right? That's one form. Another form of child in need of supervision is for children who run away, who are abscond from service, like if they're at a residential placement or from leaving their home. And often the parent might initiate because they feel like they need help. The other category of CHINS is just called a child in need of services, which focuses on kids whose sort of behavior and conduct, that often this happens as a parent or other people in the child's life start to see the child kind of spiraling out of control. And criminal charges haven't been brought yet, but the conduct is so serious that it threatens the safety of others or threatens the child themselves. And so this petition also goes to juvenile court and follows a similar process as what I'm going to talk about for delinquency charges. However, it's not supposed to be treated in the same kind of criminal way, in that kids should not be detained for these violations. But there are some very serious consequences. So a child can be put on probation, limitations on their driver's license. Both the parent and the child can be ordered to participate in treatment or services, or community service. For children who, so then the court can put a court order in place saying, go to school, or else you're going to have these consequences. Say the kid keeps being truant, then the court can find a violation of the court order, and more serious punishments can be put into place. So the child can actually be removed from the home in a foster home or placed in a detention facility at that point after violations of the court's order. So whereas this seems like, a mechanism that families might want to use if they're feeling like they're kind of losing control of their kids and they're worried about their well-being. It's also concerning because what we see is sometimes this snowballs, and a kid is now under the supervision of the court. The court is monitoring the child, and with that monitoring comes an attention to school attendance, curfew, drug tests, all sorts of things that are opportunities for the court to then sort of violate the child and the child to get deeper and deeper into the system. So in an ideal world, right, a parent would be able to access services without calling on the juvenile court to get involved. And this is sort of the theory behind, many of you may know about the FAP team. So the Family Assessment, I always forget what it's called, the Family Assessment and Planning Team, which each jurisdiction has one. And the idea behind this is that a parent or a service provider should go to this FAP team if there's a child in need of a specific kind of service or residential treatment or something like that. And this team decides, is a child eligible? Do they get the funding from the county and state to go to that program, right? And so ideally, parents would be able to use that mechanism rather than this court process to get the child the services they need. But I know on the ground, I've talked to families who have exhausted that and are at their wits' end and just want to protect their child and end up using one of these mechanisms to get into court. According to DJJ, the Department of Juvenile Justice in Virginia, let's say 14.5% of the petitions that to juvenile court were in these kinds of cases, as opposed to delinquency charges. All right, thanks, Rob. Okay, so back to this slide again, real quickly. I want to talk about, we are the part where, it's funny because I can't point because I'm not sharing my screen, but the CSU intake part. So what's happened here, or actually first we're going to talk about police contact. So the next couple points, I want to talk us through this process and where the points for parent advocacy are, especially for kids with disability. I like to think of each point as an opportunity for parents to advocate for the child or for kids to advocate for themselves. So first chance, right? Police contact. We talked about this a lot at our last session 2 weeks ago, but I really think of this as this, initial point of advocacy, because if you can convince that officer that they don't need to press charges, right? We don't have to deal with everything that comes after. So how do you do that, right? So police officers are sort of looking at things, if they're in this situation, looking at things as a crime. But I would challenge, did a crime actually occur? Because perhaps there wasn't any criminal intent. So in law school, we learned this is like mens rea, right? The mental state required for a crime to have happened. For folks with disabilities, something may very much look like a crime, an assault or a theft, when actually it isn't. So it's kind of like swinging a baseball bat. So if you're swinging a baseball bat to hit a baseball, right, not a crime. But if you're swinging a baseball bat to bash somebody's face in, then crime, right? And so the officer may see a child swinging a baseball bat around a bunch of people, and that very much looks like a crime. But then with a little bit of additional information about that child, what that child is experiencing, what was going inside in that child's brain, then you see that it's actually not a crime at all. So how do you do that? Educate if you have a chance. This is assuming you have a chance to have an interaction with the police officer before we get to that next step where they filed a summons or something like that. So if you have the opportunity, right, tell them about the child's disability. Tell them about one thing that I find really useful when talking to people who are unfamiliar with kids with intellectual disabilities, for example, is what age is this child operating as, right? Maybe on the outside, they look like a 17-year-old, but maybe actually an assessment has said they're operating more like a 7 or 8-year-old. And that can really help explain, it's also for kids on the autism spectrum disorder, like with autism spectrum disorder, there sometimes can be ways of communicating, whereas this child can do this skill set at this level. Actually, what you're seeing here, think of this more as like, a 2-year-old throwing a temper tantrum or something like that. It's a way to kind of overcome a barrier the person might have to kind of seeing how the disability is impacting the behavior. Another thing would be, some of the things associated with disabilities, right? Impulse control, judgment could impact what's happening in the moment. So you can, in that moment, educate the officer about what's going on. One thing that's not within your control is whether there's a victim who wants to press charges, right? This is something that the officer is taking into account in the moment, and that later on the court services unit will take into account as well. But oftentimes there might not be, right? It might be a teacher or somebody involved in the situation who doesn't have interest. If that's true, that person does not see benefit and you have that information, definitely share it. And then in terms of mitigating circumstances, right? These could be things that are mitigating culpability, meaning sort of the child's blameworthiness for the crime. So for example, maybe that, I had a case of a child who all these behavioral problems happened in school, but we later learned that the night before the child had had a court proceeding in their foster care case and learned that they weren't going back home to mom, right? That is a huge mitigating factor to understanding why that child was not in control of his behavior the next day. Maybe the child switched medication. Maybe there was an unannounced fire drill at the school that day or something triggering event. And then another thing is to offer the officer an alternative to thinking of this as criminal. So I think this came up a couple weeks ago where folks talked about, should we be asking for an emergency psychiatric evaluation for our child? Is that a good kind of route to go to try to dodge criminal system? It has some of its own negative consequences for sure, but if that parent or person on scene can voluntarily take the child for treatment, for an evaluation, rather than having it be mandated by the state or initiated through the juvenile court process, all the better. And so if a situation's escalating, there's an officer there and you are able to remove your child or go seek treatment elsewhere, that might be a way to diffuse the situation. Okay, now we're going to court services unit intake. So we've gotten the incident, we've got police contact. Regardless of what happens at the police stage, assuming the case is not diverted successfully, meaning it goes away, I feel like there's always an exception to everything I say. 99% of cases are going to go through the court services unit. Next slide, Rob. Okay, so the court services unit serves a lot of functions, right? This is associated with a court system and most relevant for our purposes, they do intake. They review all complaints of a juvenile, and their first, I guess, primary question is, are there facts to support this? Meaning, was there probable cause that a crime happened? And then they make a determination about whether they can resolve that crime informally, or whether a court needs to be involved to respond to that crime. And the intake officer can place the kid in detention if it's been a serious crime and there hasn't been a detention hearing yet. And they also provide intake services for custody and visitation and those kinds of cases too. So sometimes these folks are already familiar with families and families are already familiar with them. As a side note, I just want to cover sort of all the different roles that the CSU can play. They also can be involved in investigation. So back, like a lot of times a judge might order a social history, a study of the child, when trying to determine what to do, what is the best interest of the child. They kind of supervise all that, looking at the kid's family and social and educational history. They also are the body responsible for supervising probation. So if a child is not is involved in court, but not being committed to DJJ, not going out of home, but on probation, they kind of supervise the terms of that. Are they meeting curfew, drug testing, all those kind of things. And then parole too. So kids leaving secure facility, returning home for a period of parole. And then they also are responsible for keeping tabs on kids who are in residential care. So that's all kind of what the court services unit does. But for intake purposes, right? This is a great opportunity. This is my favorite opportunity for advocacy for families, because I think families can be really effective in getting the court services unit, the CSU, to not forward the case to court. Well, let me just look at this because I know if it were me, I'd want to read the screen, right? So the chart I have on the right here tells you how many cases actually end up going forward. So it's about 60%, 70% go forward to court. I guess closer to 70% when you include the court summonses, and about 30% end up either being diverted or resolved, meaning that kid, that crime, that issue that happened is not actually going to the court. And so they do have, 30% isn't a terrible statistic. They do have, a fair number of cases that don't make it through. So if you're going through this with a kid on your caseload or with your own child, right, this is your opportunity. This is a child's opportunity to kind of tell their side of the story about what happened. And then also to present kind of the same kind of mitigating evidence that I talked about with the police to the court services unit about the circumstances and all of that. But I think even more importantly, from a parental perspective, this is your opportunity to say, hey, I got this. Like, I understand this serious thing happened and I took away all devices for a month. He's grounded, right? Show that you are a parent in control of your child and giving consequences for whatever conduct. Let the CSU officer know whatever other consequences might have happened. Perhaps the child got kicked off a team. Perhaps the child's been suspended from school, right? There's already been consequences in place. Let them know what you're doing in response. Maybe the kid had been in therapy and you kind of dropped off, right? But now you're going to set up those therapy appointments again or get that evaluation. Or maybe you made the child write an apology letter or do some sort of restorative justice type thing where they harm, let's say they vandalized, and you said, oh, I already have been talking to the principal about on Saturday, my kid's going to show up and wash that off the school building wall or whatever it is, right? The more that you show that you as a parent are in control, you've got options and services, and you have consequences in place, the more the CSU intake worker is likely to think this does not need to be court involved, right? This kid is already getting additional help. We've got a parent we can depend on. We don't need the court. That's fine. We can go to the next one. Okay, so thinking back, right, let's assume that the child's case has been forwarded to court, right? One thing that can be raised at any time, and I actually quoted the statute here because I think it does a better job than me paraphrasing. So if at any time after the attorney for the juvenile has been retained or appointed pursuant to a delinquency proceeding and before the end of trial, if the court finds sua sponte, that means like out of nowhere, like spontaneously, or upon hearing evidence or representations of counsel for the juvenile or the attorney for the Commonwealth, that there's probable cause to believe that the juvenile lacks substantial capacity to understand the proceedings against him or to assist the attorney in his own defense. So those are sort of the two components of competency to stand trial. Then the court shall order a competency evaluation. So thinking about our kiddos with disabilities, right? Competency, especially the younger they are or the more significant the disability, may very well be raised in their case. What I like to think of is like what the kid needs to be able to understand what's happening to them, who the parties are in the room, what the consequences are of proceedings, and to be able to assist in their defense, right? To be able to tell the attorney their side of the story, to be able to communicate, right? And so kids, this question may come up. Oh, so I didn't even say when an attorney gets appointed, right? So once the kid has made it to court, that initial hearing, that's when the attorney gets involved. And right away, the attorney for the child may raise competency, or you as a parent may raise it, because you might know your child best and know that the child does not know who a judge is and can't really understand who the attorney is, right? So if competency is raised, the court will order an evaluation. That evaluation will either come back as saying the child's incompetent, in which case the child will potentially, if restorable, or that's sort of an adult term, but if the child can receive education on the court system and all that, and be raised to the level of competent to stand trial. So things kind of drag along as they get these class. I mean, it's really classes, and it can take like 6 months. The competent, that has to be foreseeable in the near future, right? We can't drag this on forever. I think it's about, let me look at my notes here, 3 months. For up to 3 months, they can get these services. If it's determined that they are not competent to stand trial, the court still has power to order a disposition of sorts. So this comes from the code section 16.1-358. But they can get, if it's a misdemeanor, the charges will get dismissed after 1 year. And if it's a felony, they'll get dismissed 3 years from the date of their arrest. Because if they're unrestorable, right, they can't, you think about sort of our constitutional rights and your ability to face crimes, that applied to kids kind of goes here. And if you're not competent to stand trial, right, you can't get a fair trial, and your freedom can't or shouldn't be taken away. There's certain powers of the court if you're a danger to yourself or others, hospitalization options, but not punitive consequences if the child's not competent. So nothing that the child says in the competency evaluation can then be used against them at the hearing later, which is an important note, either at the trial itself or at disposition. One note, for those kiddos in the adult system, competency there is, I would say, I mean, I don't want to overstate it, but perhaps like almost a little more dangerous is how I'd say it, because if you're in the adult system and not competent to stand trial, you may be hospitalized for there's not the same kind of time limits in place that are there protecting kids for how long that you might be held, or if you're found not guilty by reason of insanity, which is a narrow defense that might happen related to the crime. I've seen clients kind of hospitalized for a long time and facing a loss of liberty because of that. Okay, next thing. All right, so let's assume our kiddo is competent to stand trial, and we're going to get ready for this adjudication hearing or this trial if they're adult court. Now there's kind of always pre-trial negotiations between the defense attorney and the Commonwealth's attorney. And this can be really this and the trial can be really tough on parents because there's not a role for you really. The attorney for the child represents a child. They'll be speaking to the child separately from you. They will not be sharing information with you unless the child, asks them to or wants them to. Even if they're, even for your young children, if they're negotiating a plea, this is something that the attorney and the child are doing together, with a Commonwealth's attorney, which can be very frustrating. But I like to say to parents, look, you might not get access to all this, but you can always be a giver of information, right? You might not be able to receive the information, but you can be a giver of information. And again, give as much information as you can about, what treatment this child can get, or what you're going to do as a parent, or what the mitigating circumstances are, or things like that. One part relevant to here, either in the pre-trial negotiation phase or in the trial phase, is that there's a provision of law 16.1-274.2, which talks about education records as evidence. And And so what this provision of the law says is for a juvenile in juvenile court, it basically says their education records are admissible, which is like a nerdy legal thing that we might fight over otherwise. But here we're just saying it's admissible for the court. The IEP is admissible as among other school records. They're admissible to show intent or willful involvement. So what am I getting at? Remember at the beginning when I was talking about mens rea and having, the intent behind swinging the baseball bat to hurt someone? What this law says is those school records are admissible to get at that. So if you have an IEP and it includes a behavior intervention plan as well, and a 504 plan that talks about your child's worldview, your child's experience, your child's triggers and things like that, that is admissible. And then the defense attorney can use that to argue that the child didn't have the requisite intent to be found involved or adjudicated delinquent of the crime. So that's somewhere you can be really helpful as a parent. You can bring that information into the attorney to give to them, and call their attention to specific language that you think might be helpful. Okay, next slide. So I'm skipping trial here and going straight to disposition, because like I said, unfortunately for parents, in the ultimate question of the sort of factual question of was the child, legally, are we gonna, in the adult context, we would say, are we gonna find them guilty, right? That question, right? Did they actually commit the offense? There's not really a role for parents to play at that point. That's gonna be the lawyers and the evidence and the judge. And in some jurisdictions, that the same day that adjudicatory hearing happens, that trial in juvenile court, the disposition will also happen the same day. Remember, disposition is kind of like sentencing. But in a lot of cases, there's going to be a big gap between the two, because after the judge determines that the child was involved, meaning committed the delinquent act, the judge needs to know, well, what am I going to do with this child? That's a disposition. And in order to know that, since the system is rehabilitative, the judge needs information and time to make that decision. So often there's about a 60-day period in which a social history report is done. Remember, the court services unit does that, where we're gathering about the school, the home life, any other things going on in the child's life, services, trauma history, all sorts of things like that come into the court. And when the court decides how to respond to that child's delinquent act. And the court has really broad discretion here, right? Meaning there's so many different options a court can do to respond to a child's behavior. And it really should be individualized. But of course, like anything that depends on a human being, who your judge is could matter a lot here. And I would like to believe that all the juvenile judges in our state have internalized, what typical brain development is like for kids, understand the impact of trauma and all that. And I think many do, but of course, there are some ones that might be challenging. But anyway, so the judge has a lot of discretion. This judge might just put the kid on probation. They might order counseling, even they can order you, the parent, to have to participate in certain programming and counseling. They could order conditions, right? Curfews and drug testing and attendance at programs. Set fines, order restitution. So, if a kid takes a car for a joyride, crashes it, that's a lot of money in restitution, meaning the amount of money it will take the victim to be made whole again. Community service, other programming, and all the way up to committing the child to the Department of Juvenile Justice, which means custody of the child transfers from the parent to the Department of Juvenile Justice. All of that, I have the code section there to show where it can go. So in terms of parental advocacy, right, that social history report in talking about this is what my child's experience, this is who my child is, and this is what my child needs, again, is your chance as a parent to provide information that will help the court see what's in the best interest of your child if they're going through that. So if the court orders commitment, and this here we're talking about kids who are in the juvenile system only, right? Not kids who are committed to DJJ as adults. For kids in the juvenile system, that commitment, the child has to be 11 years or older. And they have to have been convicted of a felony, a class 1 misdemeanor, and a prior felony, or 4 misdemeanors. So in other words, we're reserving this sort of severe punishment of taking custody from you and giving it to DJJ for the more deep end offenders, for the older kids-ish, if anyone considers 11 old, which I don't. And then the Department of Juvenile Justice, if the child is committed to the Department of Juvenile Justice, it is most often an indeterminate commitment, which means that it is not the judge who says how long the child will be there. It is DJJ. There are limits on that, right? It can only be up to age 21 or for 3 years. There's a max. But that commitment to DJJ, they have length of stay guidelines kind of based on the kid's offense history and other factors, and then the offense that was committed, of how long they think treatment will take. And their goal is to, and the code demands of them, to let the kids out who've been rehabilitated, right? And serve them in a less restrictive setting than, say, the juvenile prison, Bon Air Juvenile Correctional Center. That's what the picture was on the first slide. Virginia's, barbed wire secure juvenile prison. And so I lost my train of thought there. But anyway, so the judge kind of hands over to DJJ, and they are the ones making the determination of when the kid's ready to go home. You might hear the word detention versus commitment. Commitment is that transfer of custody. Detention is jail, but it's usually jail. It's jail at the local juvenile detention center, and it's for a shorter period of time, usually can't exceed 6 months. And so the court might order a kid. These judges sometimes just really think that the kid needs to be scared straight. And so they might order them to 30 days in the local jail or something where they go before coming home. Okay, so we've kind of made our way through the process. And I just want to wrap up by talking about what do we know about disability and what I call these deep end kiddos, right? The ones who are committed to Bon Air in Virginia. Well, a lot of them do have disabilities. About 65 to 70% meet the definition according to the National Disability Rights Center, read the criteria for having a disability. 80% have experienced significant trauma before coming into the juvenile justice system. And at Bon Air specifically, this is the best data I could get for Virginia right now, about 34% of the youth have IEPs. Which is significantly more than the general population. Most school systems in Virginia, probably about 10 to 12% of kids have IEPs. And we also know these kids come in with a lot of mental health needs, and sometimes a history of treatment and medication, or if that doesn't happen prior to, it often happens while within the facility. And so that chart you can see on the right as sort of like a imperfect proxy, right, for mental health is, look at the numbers, 70% have been prescribed psychotropic medication. So that tells you a little bit about it. Okay, so I think I did a good job on time. All right, yeah. So we have about 10 or ish minutes for questions now. I have not